Porter, and have you come right up to the podium there, please. We're on the record now. 1 second. Okay, we're on the record now in People versus Jennifer Porter, case number 236508. The record should reflect Ms. Porter's present here in the courtroom. If I could have counsel for your appearances on.
Yes, good afternoon, Your Honor. Deshaun Madha appearing on behalf of the people.
Brown on behalf of Ms. Porter.
All right, thank you. We're here today for a final status conference. This matter is set for trial later this month. I see Mr. Madda, the people have submitted their witness list, an exhibit list, I believe. And Mr. Brown.
I will get that in today.
Okay, are we ready to go forward with trial then?
Yes, I believe so. We have had a plea offer in the matter. I have spoken with Mr. Madda regarding this. I've spoken with Ms. Porter. There is currently 5 felony counts. There has been a plea offer to 2 counts of misdemeanors. One, and I've gone over this with Ms. Porter. I'm not sure she completely understands it, but it is my understanding, speaking with Mr. Madda, and I wanted to make a very clear record of this, and he can speak to this as well, that if there was a plea to the misdemeanors, again, a felony conviction, she's very concerned with her nursing license would be an automatic revocation of a nursing license, whereas the misdemeanors would not be an automatic revocation of that license. That is my understanding in speaking with Mr. Madda as well, if he could clarify that.
Mr. Madda, can you speak to that issue, please?
Of course, Your Honor. And so the people, just to bring the court up to speed very briefly, Ms. Porter entered into a consent order as a matter of her administrative proceeding with the Board of Nursing. She is currently, she has an active LPN nursing license, which allows her to practice, and that will continue. She is on a 6-month probationary period as a result of the consent order that she signed. After that consent order was signed in August, the people and Mr. Brown had informal conversations outside of the court proceedings here before Your Honor. And the people sought to amend our offer. As the court is probably aware from its notes, we were previously asking for a plea to 1 of the 5 charged felony counts. Based on the consent order, the fact that Ms. Porter has continued to work without incident, and the fact that she has an active license, albeit on probation, the people are going to be making a formal new offer on the record today. That offer is 2 misdemeanor counts of MCL 750.492A sub parentheses 1B. So the only real difference here is currently the 5 counts are intentionally placing false information in the medical record. The misdemeanor plea is recklessly. It is a general intent crime, not a specific intent crime like the currently charged felony. This is a pre-trial offer only, and I have spoken to representatives from another division of my department, those that represent licensing and regulation and who appeared at these hearings. And they have represented to me that this misdemeanor offer that the people are making will not result in a revocation of her license. It will result in a continuation, possibly a slight modification of her current consent order, but not a suspension of her license. This stands in stark contrast that if she is convicted of any one of the 5 felony counts in this case, then they will be moving to revoke her license. And those are the representations that have been made to me. Obviously, I am not part of the Board of Nursing, but this is again coming from very experienced attorneys representing the Department of Licensing and Regulation.
All right, Ms. Porter, is this something you had a chance to talk to Mr. Brown about?
Not for very long.
Okay, do you want some more time to discuss that with him here today? I think you should take
I
some.
mean, a lot of stuff got pushed under the rug. I didn't even talk to him for a month after I did my resolution. Should have been submitted to the Attorney General in August. And he doesn't call me until September 7th. You know, this is my livelihood, you know,
Your Honor.
like think about, because I work short staffed. I had my
Well,
timing errors. I didn't have no missing medication.
Your Honor, I advise you not to say anything right now.
I don't want you to say anything on the record. So what I want you to do is have a discussion with Mr. Brown here today.
I'd like a new lawyer.
Okay, well, you know, you're free to hire a lawyer at any time that you want.
Well, I would have done that had I not been put on leave of my job because of this. So,
If you want to submit a request for a new lawyer, that has to be submitted to the administrator who handles the appointments. But let's talk about that in a little bit. What I'd like you to do is just have a discussion with Mr. Brown for a little bit here today. See if that helps or makes a difference. If it doesn't, then we'll come back and we'll talk some more. Okay. All right. So Mr. Brown, go do that. Thank you. Mr. Manna, I'm just going to put you in the waiting room. I think Ms. Porter needs to speak with her lawyer a little bit here. So if you don't mind just staying on the line for a little bit.
Of course, Your Honor. Thank you.
Thank you. All right, Mr. Trush, I don't see Mr. Evans, but I've asked Ms. Jennifer to make some calls over to Alpena to see if we can connect it. So while we're waiting for that, we'll take a short recess and be back on the record in about 10 minutes. We're back on the record. Ms. Porter, how do you want to go forward? Mr. Matta, what is the maximum penalty for those misdemeanors?
For the misdemeanors, it is 1 year and or $1,000 fine.
All right, and Mr. Matta or Mr. Brown, are either of you prepared to take the factual basis here based on the information? I'm not sure if this should be able to do that.
You have that right in front of.
I'm sorry, I could not hear Mr. Brown.
Do you have that right in front of you? Otherwise, I can try to pull this up.
I do, Your Honor. And I can state that now for the record. In August of 2022.
Well, hold on. Let me go through my colloquy with Ms. Porter first, and then I'll indicate when it's time for that. Okay.
Thank you.
Ms. Porter, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Ms. Porter, do you understand that the statutory maximum possible penalty you could face for each of these misdemeanors, as Mr. Matta just indicated, is up to 1 year or $1,000 fine? Yes. And what is your plea to those charges today?
Guilty.
Right now, you have certain rights, and I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yeah.
You understand that by pleading guilty, you're giving up and waiving all of those rights.
Yeah.
Is anybody forcing you to do that today?
No.
Has anybody threatened you with anything to get you to plead guilty? Sorry, can you answer that question again?
No.
Has anybody promised you anything other than what we've said here on the record today?
No.
Is it your own free choice to enter this plea?
Yeah.
Are you pleading guilty because you are guilty?
No.
So I can't accept a guilty plea from you if you're not guilty of the crimes. So the only other option that leaves us is going to trial.
I just haven't had time to think about all this at all, being told the day before. It's been a lot for me anyways to digest, so, since February.
Your Honor, we have had a very difficult time in communicating the difference between intentional and reckless.
They're both terrible, it doesn't matter.
She would not be pleading, and I don't know if she understands, to something that was reckless, not something that was intentional.
Okay, so again, the crimes that you would be pleading guilty today essentially is more of a negligent act than it is something that you did on purpose.
I accepted that with the board of nursing. I should have reported the facility for the staffing and the mandates, so
Okay.
I was behind every shift, so it doesn't matter. But the media said that I did it to cover medication not given, is what Nestle's office said.
And Your Honor,
That was
again, I
terrible.
would advise you not to say anymore, but we have had discussions.
Can we just do this?
About media.
I want to go home. I work midnights. I'm tired. 3 hours drive.
But I do honestly believe the biggest confusion is between an intentional act, which these are not.
Well, Mr. Matt, I'm going to have you ask Ms. Porter some questions, and then we'll see if we have a factual basis or not. So,
I understand.
Mr. Matt is going to ask you some questions, Mr. Porter, about your actions, and we'll see if they equate to a violation of the statute. Go ahead, Mr. Matt.
Thank you very much, Your Honor. Ms. Porter, in August of 2022, were you working in your capacity as a licensed practical nurse for Metalodge of Gaylord?
Long-term care is brand new to me, and my career was spent in home care, doing home care. Why I took travel nurse and came up here, I don't know. I was not. They hired me, so apparently they thought my resume was good enough. But my long-term care experience has been a nurse since '08, and I had 6 months long-term care that when I finished school, and we were on paper, not EMR.
All right, but were you working at that facility at that time?
Yeah.
Okay. All right, Mr. Maddox, go ahead.
Thank you very much, Your Honor. And again, in August of 2022, through that employment as a licensed practical nurse, were you responsible for distribution of medication, otherwise known as a medication cart nurse?
Yes, sir.
Thank you. Did Metalodge of Gaylord approach you with a series of documentation errors
Yes,
that you
timing
made?
errors. Yeah.
But if you can, just let him finish the question because with the delay here.
I'm sorry, he hesitated, so I thought he was done.
Go ahead, Mr. Maddox.
Thank you very much, Your Honor. And I apologize for the delay, Ms. Porter, but if you could just wait for me to ask my question, please. With a series of documentation errors that occurred as a result of your appointment in August of 2022.
What was that? I'm sorry.
Did your
Can you
employer,
re-ask it, Mr. Maddox?
Yeah. Yes, I
Okay.
may. Did your employer, meaning Metalodge of Gaylord,
Yes, okay.
approach you demonstrating that they found several medication errors, medication documentation errors that you made in August of 2022?
Yes, yeah, they had copies.
And those
of the charting, whether it was written, sign out, or in the computer.
Yes, that's exactly what my next question was going to be. In other words, you had to log in the medication administration record for each resident that you were attending to in both a paper administration record as well as what you referred to here in court as a EMAR, that's EMAR, which is also known as an electronic medication administration record.
Yes.
And that is part of each resident's medical record, correct?
Correct.
Your Honor, I could ask specific questions about each particular date and those specific medication errors, but I will defer to the court in terms of whether a factual basis has been set forth based on what she has stated.
I think we just need, did that happen at least twice?
Yeah, I signed it out, and then I didn't sign it out in the computer till way later.
Okay.
So the times didn't match up. They had my signature, with the time that I signed it out, that it was actually given. But because sometimes I just couldn't go back to the computer to chart, and some were as needed met, so you have to go in a different area of the computer. Nobody showed me when I hired in there that you need to match it and change your time back. I never worked with point click care before, so and I got a day, I think, of orientation. No, a Thursday and a Friday, and then Monday I had to work that weekend. They sent me on my way Saturday.
All right, and okay, I think we have a basis for 2 incidents. Mr. Matt, are you satisfied with the factual basis?
I am, Your Honor. I would just add one other thing that the defendant has already alluded to, but I would like to state it as part of the factual record as well. Ms. Porter, in the consent order that the people referred to in August of 22, you admitted to, in fact, negligence while you were on duty, which is a violation of the Administrative Code, Section 16221A, as well as your conduct during your employment as a nurse as being a departure from the prevailing practice of the health profession in violation of 16221B sub 1 as well, correct?
Yeah, I wanted to get through this. I haven't worked as a nurse since February, so I work, I'm a supervisor at night at Axion Corporation now, so.
Okay. All right.
Thank you.
Mr. Matt, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Brown?
Yes, sure.
All right. Mr. Mata, are the people aware of any threats, promises, or inducements other than what's been placed on the record here today?
No, Your Honor.
Mr. Brown?
No, Your Honor.
And Mr. Mata, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Brown?
Yes, Your Honor.
All right. The court finds the plea is knowing, voluntary, and accurate. The court is satisfied based on the testimony here, as well as acknowledgement of the consent order, that there is a factual basis. The court will accept the plea as to both charges. And we'll set this matter for a sentencing hearing. Ms. Mata, or I'm sorry, Ms. Porta, you're notified of the date and time of that hearing. I would request just a short misdemeanor PSI, so you're going to meet with Ms. Davis here before you leave the courtroom. Mr. Mata, anything further on behalf of the people today?
No, Your Honor, other than if the court would like me to dismiss the remaining balance of the charge information, I can do that today, or we can do that on the date of sentencing.
If you can just have the nollies prepared and submitted to the court, then I'll sign those on the day of sentencing.
Thank you, Your Honor.
Okay. All right. Thank you, Ms. Porter. That's all for today.
Just one thing before Mr. Matta leaves. Do you happen to have the PAC code?
I'm sorry, one more time, Mr. Brown.
Do you have the PAC code for the charge?
I'm not sure what you're referring to. I'm sorry.
We'll
Are you
take care of
talking
that.
about?
Yeah.
Yeah,
We'll take care
is
of
that
it.
okay? Thank you.
We've got the statute that you cited at the beginning.
Correct. In the PACC code, if that's, I think that's what you're referring to, should be the exact same. Again, as the prior charge, we only simply changed the subsection.
All right. Thank you. That's all for today, and you're free to disconnect at this time. Also, the
Thank
court
you.
will adjourn the current trial dates based on the plea. All right, Mr. Evans, are you able to hear me okay?
Yeah, I can hear you, Your Honor.
Thank you. We're on the record in People versus Jason Evans, case number 216127. The record should reflect Mr. Evans is present today by video from, I believe, Alpena County Jail. If I could have counsel put your appearances on the record.
For the record, Your Honor, Mike Roloff, down to the people.
Thank you, Your Honor. Richard Schuster, appearing on behalf of Mr. Evans.
All right, I think we're on for final status conference today. We currently have trial dates set in this matter to begin on October 31st, later this month. Mr. Rolla, are the people prepared to go forward with trial as scheduled?
We are, Your Honor.
Mr. Trush.
Yes, Your Honor, we are prepared to proceed forward.
Okay, Mr. Rolla, are there any matters that need to be addressed prior to the trial date in terms of any kind of motion practice?
The only thing I would have indicated now that the defense had filed a motion to suppress, which was then denied by the court, the only offer that would have been open would have been to plead to counts 1 and 2 as of official the second. That also expires. I didn't want to try and talk over that, Jeff. Expires today.
Mr. Trush, are there any pre-trial matters that are going to need to be addressed before the morning of 30?
Just one issue that I think we probably can take care of today We have a witness that is being written from MDOC to testify for the defense. My intentions were to writ him for the morning of 11/1. I guess I'd just ask if the prosecutor thinks that's an appropriate time based on his proofs.
Again, I don't think that's gonna be an issue.
I mean, do you think, is it gonna take you a full day to put on your proofs, including jury selection, of course?
Probably,
Okay.
with jury selection, yes, Judge.
All right, so I think that'll work then.
And I would indicate, I don't anticipate he's my only witness, so there is a little bit of wiggle room in that as well.
All right, then as is the court's practice, Mr. Rolla, I'll ask that you submit your proposed jury instructions and verdict form. Mr. Trush, if you can just submit any objections you have to the prosecutor's instructions or any additional or different instructions that you would like, as well as any objections to the verdict form. You could have those 7 days prior to the trial date. Mr. Trush, obviously, you also need to make sure that Mr. Evans has street clothes for his appearance. And I believe Mr. Evans has already been here, is that correct?
I think that's correct, Judge.
If you can double check that and make sure we have a writ for Mr. Evans to appear on the morning of the 31st.
He was in the Alpena County Jail, Judge, and then he'll have to be brought here.
Great, okay.
Can we just make sure that the writ is to bring him to the jail? I know that there's been issues in the past, both here and in other courts, with inmates being brought in the jail clothing.
And Judge, I can address that specifically. The writ will indicate to be transported to the Otsego County Jail for a change of clothes.
Okay,
If they can't understand that, there literally is nothing else I can do about it.
okay. Okay,
There is one additional issue not related to the trial I would like to.
okay, go ahead.
I believe that Mr. Evans' bond here has been canceled. He has inquired about getting those funds returned to him.
So,
Normally it's when he's been sentenced. But I don't show that it's been, when was it canceled? Because it still shows it's posted.
I believe it was canceled at the last hearing, but ultimately, if it's not canceled, we would need to have it canceled.
I don't believe it's been canceled, Richard.
I have May 22nd stipulation to cancel on.
Okay,
I don't know if that order was signed, or Judge, that's what I was looking for.
No, it was.
it was May 22nd. Yes, sir. And it looks like Mr. Evans did post the bond on the inside of the court file. The bond slip.
Oh, $500.
Did he post it? And then that sheet coming.
Okay, or yes, it's been.
Okay, okay, yeah, I can take care of that.
Okay, so we'll release those funds to Mr. Evans then. Anything else, Mr. Trush?
No, thank you.
Mr. Evans, did you have any questions at all?
I would just ask those funds be sent to my sister.
The check will be in his name.
Yeah, we can send it to whoever you want. The check's gonna be in your name though.
That's fine.
Okay,
I just don't want it sent to the jail here in Alpena.
What address, sir?
can you give us the address where you'd like that sent?
I actually don't know where I am.
I can
I don't
provide
know
that.
where I am, Mr. Honor. Is there any way Mr. Truce could contact her and get it from her? He has her contact information.
I can do that. I can provide the court the address before the end of the week.
Thank you.
Okay, yes, Mr. Trush will take care of that.
Thank you, Your Honor.
As a housekeeping matter, if he's still gonna be in Alpena, we'll have to have him written from there, because I don't believe we still yet get an out date from Alpena.
Mr. Evans, do you anticipate you're still gonna be lodged there in Alpena by the 31st of this month?
As of right now, yes, Your Honor.
Okay.
Then that's what we'll deal with. Thank you, Judge.
Okay, thank you. That's all for this hearing today. The court's gonna disconnect at this time.
Okay, thank you.
People versus Andrew Wolverton, case number 236556. Wolverton, if you come right up to the podium there, please. Record should reflect Mr. Wolverton's present here in the courtroom today. If I could have counsel put your appearances on.
For the record,
Ray Brown, on behalf of Mr. Wolverton.
This is the date and time set for sentencing. Mr. Wolverton, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, Your Honor.
Okay. Mr. Brown, are there any additions, deletions, or corrections that need to be made?
No, Your Honor.
And there are no scoring since this is a misdemeanor. Mr. Rolla, any additions, deletions, or corrections?
There is only one addition, Judge. But it's probably goes more as to sentencing as opposed to body report. I'll address it in allocation.
Okay, allocution then, please.
Thank you. This is a circumstance, as court's well aware, we're dealing with a controlled substance situation. We would add that as any condition the court's going to impose, since as indicated in the PSAR, although the defendant was enrolled, for lack of a better term, at getting sessions at Gentle Harbor, he apparently has not been attending them with regularity. So we would ask that when the court's imposing, if the court's imposing an order of probation, that probation order include that he follow all of those conditions for that type of substance abuse treatment and assistance, as opposed to doing it when he feels like it. Thank you, Your Honor.
Mr. Brown, anything on behalf of Mr. Wolverton?
Your Honor, there is one change to the body. I apologize. Very, very minor. I was informed by his father, who's also his guardian, that his place of birth was Southfield, not Pontiac.
And no objection there at all, Judge.
Okay, the court will order that correction. Anything for allocution, Mr. Brown?
Again, this is a very unfortunate set of circumstance. He's been under the guardianship for a significant amount of time right now. Not that he did not do anything wrong, but he was very easily persuaded. I would just ask the court to take that into consideration and adopt the recommendation.
Thank you. Mr. Wolverton, was there anything you wanted to say today?
I do have $301 in cash to pay my fines.
All right, I read through the report, so I'm familiar with why you're before the court today. And I think based on the circumstances that jail time is not warranted in this case, but I think you do need to be very careful about what you're doing as you go forward, because you get involved in this kind of thing again, that might be something that happens. So it's really important that you take advantage of any kind of programs that are available to you to help you, because those are the kind of things that will hopefully prevent this kind of thing from happening again.
Yes, sure.
So I think, again, that the punishment here should be financial as opposed to you going into jail, all right? The court is going to impose a crime victims assessment of $75, a state cost of $50, court costs of $325, attorney fees of $350, and restitution in the amount of $475 payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics. I didn't say the DNA testing fee of $60. After court, downstairs is the clerk's office, and you can go down there to make arrangements to pay whatever you can pay today, and then have a plan for the rest, okay?
Yes, sure.
All right,
May I ask one more question?
sure.
Would I have to do the DNA testing today, and if so, where would that be?
I think they may have already done that. You just have to pay for the process.
Okay.
They did that, they took the sample at the time of arrest, Judge, pursuant to statute. This is just to reimburse the state for the cost of having it tested.
So thank you. That's all for today. And Mr. Wolverton, let's not have you back in front of the court, okay? Don't do this kind of thing anymore.
Thank you.
Thank you. People versus French, case number 236475.
For the record, gentlemen, I call that the people.
Thank you, Honor Richard Trush, on behalf of Mr. French.
And this is set for sentencing today. I understand we've had a series of issues with Mr. French. Trying to locate him. I know at one point he was lodged at Sheboygan, then he was released. Now I understand Mr. Trush, based on a message yesterday, that he's checked himself in River, maybe some other facility. Is that correct?
So yes,
Can you update me for the record? Thank you.
Yes, to try to give the court a little bit of the background, we were set for sentencing, I think originally back in June. On that date, Mr. French was not here. It's believed that he was in the jail in Sheboygan, although that's not 100% clear. Subsequent to that, we know he at least was in their jail again. We filed a stipulation to rescind the bench warrant for his non-appearance at that hearing, which brings us to today's date. I contacted the Sheboygan jail ahead of today's date to discuss the matter with him, only to be informed that he was again no longer in their jail. They informed me they thought that he was in Otsego's jail. I contacted the jail here. He was not here. I was eventually able to determine that he had checked himself into a rehab and was ultimately able to confirm that he is in Bear River and not Boyne right now.
Okay.
I spoke to him on the phone yesterday. I believe he's still in the detox program. He told me they would not let him out to come to the hearing. I did believe he'd be able to be on via Zoom. And that's everything I have.
All right. Ms. Davis, do you know, have we even been able to have a PSI prepared in this case?
No, I just reviewed his documents and he failed to appear for his PSI interview where Agent Leo did a case report to the court. So that's where the confusion coming from. So he accepted the plea, but we haven't been able to get a hold of him.
Okay. Mr. Roll, the people that are input, how to proceed today.
Well, Judge, in light of the type of charges, obviously getting him into detox is a good thing. The only problem is
This is the national. Every cell phone in the country.
I turned it up. Testing the emergency alert system.
The 220.
Yeah, that's the government putting tracking on your phone.
Right.
No, that would take, that's
Making
making
sure
sure.
it's still there.
Well, it works.
If I may continue, thank you. As I was saying, although it's a good thing that substance abuse is being, treatments being sought, that shouldn't be used as a way of avoiding court's orders. Because again, if the court is an order, it's not a request. Now, I understand that there was an issue with the bench warrant back on June 20th, and I agree with Mr. Trush that there was stipulation you have to recall. But also, my personal contact with Deputy O'Henley in Sheboygan County confirmed that when the defendant was supposed to be here before, he was not in the jail at that time. He did go back after those court dates, but he was able to come here. He chose not to. The court wants to do this as a bench warrant, specifically if for no other reason than the defendant not appearing for its PSI interview, the court has to enforce its own orders.
Right. So, okay, taking into consideration what both counsel had to say, as well as Ms. Davis, in terms of the status of this case, certainly the court has an interest in encouraging people to seek treatment when they have substance abuse problems. There's a right way to do that. There's a wrong way to do that. I think this is an example of the tail trying to wag the dog here. Mr. French has not been cooperating with what he's been ordered to do at all since he entered his plea. And I don't think it's appropriate for individuals individuals to check themselves into rehab as a way to avoid complying with court orders or to face sentencing for charges that they pled guilty to already. So while Mr. French seeking treatment is admirable, the way in which he's done that is simply not permissible and the court can't allow it. So Mr. Roll, I'm going to ask that you prepare a bench warrant for his arrest. Mr. True, should you have contact with Mr. French, please inform him that as soon as he can be released from Bear River, he needs to turn himself in at jail. Otherwise, he's going to be arrested and brought into the jail. He wants to seek treatment as part of his sentence in this case. It's something I certainly would be able to do. But at this point, we need to get this case. So that's it for this file. Thank you. I think we have Mr. Starnes signing in here for Delta County. Mr. Starnes, are you able to hear me okay?
I'm here, and I can hear you guys.
All right, thank you. We're on the record in People versus Hunter Starnes, case number 236563. The record should reflect Mr. Starnes is present today by video from Delta County Jail. If I could have counsel put your appearances on the record.
Thank you. For the record, I call that people.
Mr. Starnes.
This is the date and time set for sentencing in this matter. Mr. Brown, did you have a chance to go through the report with Mr. Starnes?
I did, Your Honor. I believe I sent his I reviewed it with him September 28th.
All right, Mr. Starnes, did you have an adequate opportunity to go through that report and talk to Mr. Brown about that?
Yes, Your Honor.
All right, Mr. Brown, are there any corrections, additions, or deletions to that report?
No, Your Honor.
Are there any challenges to the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
None, thank you.
Anything on behalf of the people for allocution?
Justice, as the court, I'm sure noticed with PSI, this is a circumstance where the defendant somehow thinks it's a good idea to steal vehicles, drive them till they run out of gas, and take another vehicle and drive till you run out of gas and continue on until he gets caught, which is what happened in this particular case. And the court took a plea and they took on the record a restitution of $9,953.52. As the court is well aware, under the Crime Victims' Rights Act, companies, businesses that provide insurance and that pay out restitution that turns out as a result of the defendant's criminal activities are considered victims under the Crime Victims' Rights Act. So the fact that Fremont Insurance was asking for the amount of $9,953.53 is appropriate. We were advised apparently more recently that they wanted an additional amount on something that additional, I guess, $500, I think was the.
No, you're saying right now. It's
Huh?
9,009.
It is the right one? Okay, all right. So in any case, oh, it was the $100 deduction. That's it. Thank you.
Oh, it's included.
That's included already? So the amount is $9,953.52, which has already been paid out to the victim. They want reimbursement for that. I think it should be appropriately ordered under the court pursuant to the Crime Victims' Rights Act. As far as the recommendation, in this case, the guidelines are 0 to 9 months up to 2 years. This is the second felony. So I don't believe a 93-day misdemeanor sentence under the statute where the court can do that for unlawful use of motor vehicle would be appropriate. Thank you, Judge.
Thank you, Mr. Brown. Anything on behalf of Mr. Starnes?
Your Honor, there's not a lot I can say here. Mr. Starnes is still very young. I believe he's in his early 20s. He is currently incarcerated, which is clear. I don't know what was going through his head at this time. He made a very, very bad decision. It looks like he made a series of bad decisions. However, given his age, I think that he is far from beyond rehabilitation with some proper services or any kind of proper help that he might need. I'm not going to go into some of the things in the PSI regarding his childhood, aside to say that it appears it was very traumatic for him. While that is never an excuse, it does provide possible reasons that, you know, maybe he thinks the way he does or he's thought the way that he does. However, there are going to be consequences. There are consequences for this, of which he's aware of. So I think the court should take those things into consideration when fashioning a sentence, and I would ask the court to adopt the recommendation.
Thank you. Mr. Starnes, was there anything you wanted to say today?
Yeah, to start off, I do want to apologize for my actions. Normally I don't act upon my thoughts like the way I did, but I was just having a rough day, and for some reason I thought it was a good idea to try and get out of town, to try and get away from my family. And I've never stolen a vehicle like that before, but I just decided it was a good idea to steal a vehicle and to leave town and to do the things that I did. And I do wish that I never chose to do this, but I do plan on getting help when I get out of jail and going to rehab for not only myself, but for my mental health. So that's all I'd like to say, Your Honor.
I did review the report. Mr. Starnes, I'm familiar with why you're before the court today and the circumstances involving the theft of this vehicle. There's also lots of information in that report about your history and your background. So taking all that together along with what the lawyers had to say and what you've had to say, certainly I agree, bad instance or instance of very bad judgment. This is a property crime. Nobody was injured, but certainly the individual that this truck belonged to had a fairly large financial loss, as well as just the psychological impact of having your stolen, having to go through this whole legal process of dealing with that. Certainly something that the victim in this case didn't ask for or didn't deserve as part of your course of conduct. So I do think some jail time is appropriate to impress upon you the wrongfulness of your actions. I think it's also important as a deterrent effect. And I also think some probation is appropriate as well to provide some oversight to make sure that you get on the right path and you stay on the right path. So the court is going to place you on probation for a period of 2 years. The court is going to adopt as the conditions of the probation, all the terms and conditions that are listed in the report. The court is going to impose 6 months in the Otsego County Jail. You do have credit for 57 days served. That's to be served concurrent with any sentence you're currently serving. The court is going to order restitution in the amount of $9,953.52. That's payable to the Otsego County Clerk to be dispersed to Fremont Insurance. A $30 per month supervision fee while you're on probation. Court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You do have the ability to seek an appeal of this sentence. If you haven't already received it, you will be provided with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Roll, anything else we need to address today?
Not from the people, thank you, Your Honor.
Mr. Brown?
No, Your Honor.
Right, Mr. Starnes, that's all for this hearing today. You'll be provided with written documents outlining your sentence in this case, and good luck to you going forward.
I believe that is my day, Your Honor.
Okay, thank you. We have Mr. Hilliker present. Ms. Berta, are you signing in on the Hilliker matter?
I am, Your Honor.
Okay, 1 second. Mr. Truce, I get the attorney record on this file.
I am.
Is that Mr. Hilliker there?
That is not, that's Mr. French.
Mr. French. Okay. It's not connecting his audio. Mr. French, if you can hear me, you need to contact your lawyer as soon as you can later on today. Okay, we're on the record in People versus Hilliker, case number 236541. If I could have both counsel put your appearances on.
Christy Berta from the Attorney General's Office for the People.
Thank you, Your Honor. Richard Truce appearing on behalf of Mr. Hilliker.
All right, this matter was set for hearing at 2:30. It's now 2:33. Mr. Hilliker is not present. This was set as a show cause today. Mr. Hilliker did not appear back in September. Mr. Truce, have you had any contact with him over the last 30 days?
I am not, Your Honor. The last contact I had with him was the day before the September 7th hearing. I have not heard anything from him since then.
All right.
Although curiously, from my discussions, my limited discussions with the Attorney General, it does appear he may be paying his child support.
All right,
Yes,
Ms.
Your Honor, he
Berta,
does. He is employed apparently at BC Pizza of Boyne, Inc. And there is a withholding order in place. The last payment received was 9/22.
all right, do you have any position with how the court should proceed today in light of that? And also the fact that he has not appeared for the last 2 court hearings?
This is his second failure to appear, Your Honor. I guess I'll leave it to the court's discretion.
All right, in light of the fact that he hasn't had contact with you, Mr. Truce, and that he hasn't appeared for 2 hearings, and in spite of the fact that a bench warrant or an arrest might interfere with his work and ability to continue paying, I don't see how I can allow him to continue to just not appear for court, and certainly no excuse for not at least contacting you as his lawyer. So, I mean, at this point, I don't think I'm gonna have much choice other than Ms. Berta to ask the people to prepare a bench warrant for his arrest, and once he's arrested and brought before the court, we'll proceed further with this case.
Thank you, Your Honor. We'll take care of that.
All right, thank you, and Ms. Berta, you're free to disconnect at this time.
Thank you.
People versus Gens, case number 236546.
People.
Thank you, Your Honor. Richard Shoestring on behalf of Mr. Gans.
Set for a status conference in this case. Mr. Truce, can you tell me where we're at with this battle?
Yes, Your Honor. We are going to ask the court to docket this matter for a trial. I would ask the court, given where the trial dockets appear to be at this point, to set a final status conference the month of the trial.
Mr. Rolla, how many days of trial do you think we will need for this case?
This may take at most a day and a half. Maybe even be able to be done in 1 day. I don't know, Judge.
I think given the nature of the charges, I think they longer for jury selection, so I think 2 days, Mr. Truce.
That would be my suggestion.
And Judge, I would concur with defense counsel's request of a final status conference. There's an offer out of an added count to a CSC court incapacitated victim that lowers it to a G felony. And defense counsel had not really discussed that with this client.
Mr. Rolla, are you anticipating any pretrial motions?
I'm looking at this and I don't really think so.
And that, Mr. Truce, are you aware of any motions that you're going to be filing?
I think it's unlikely. I would indicate to the court, I anticipate that I'll probably file a Brady request. Absent needing to file a motion to compel, though, I don't think that's going to likely result in a motion.
Doesn't appear that there's going to be any additional motions filed on behalf of the people, Judge. Thank you.
All right, thank you. So the court will set it for a 2-day jury trial. We will set it for a final status conference prior to the trial date. To the extent that either side does have motions, they would need to be filed and set for hearing no later than the date of that final status conference. Also, that would act as the plea cutoff. So, Mr. Gantz, before that final hearing, before trial, just make sure you stay in touch with Mr. Truce so that you're ready to decide at that point whether you want to accept any plea offers. Okay?
Yes, Your Honor.
Mr. Truce, anything else you need to address on this file?
I don't believe so.
Mr. Roll. Mr. Gantz, that's all for today. A little ahead of schedule. Is Ms. Daniels present?
Yes.
Do you need to speak with her? Or
I would like just a moment to speak with her. I would indicate we do have Mr. Stevens present.
okay.
Again, I think we're a little ahead on this case.
People versus Stevens. Case number 236484.
The record, Your Honor, I call that the people.
Thank you, Your Honor. Richard Trish on behalf of Mr. Stevens.
And this is supposed to be set for a sentencing hearing today. Ms. Davis, my understanding is we haven't been able to complete a pre-sentence report. Is that correct?
Correct, Your Honor.
Okay. Mr. Truce, have you talked to your client? Is there any reason why he hasn't complied with that process?
Yes, Your Honor. I think this is just some difficulty in communication. Mr. Stevens was in the county jail at the last hearing. The court amended his bond and allowed for him to be released. He returned to where he resides in the UP. The phone number that I had for him was no longer a good number. That was what the Department of Corrections got for me when they asked. They tried to contact him at that. I didn't know they weren't able to get in touch with him until about 2 weeks ago when they communicated with me and said, hey, we haven't been able to get a hold of him. I reached out to him through the email that I had for him and was ultimately able to get communication going back and forth with him, but it just wasn't enough time for us to get that PSI done. I think that today he can provide contact information to the department, and we should not have this issue again.
All right, Mr. Stevens, my plan was to just have you arrested here today and taken into custody so that we can make sure that this gets done. I'm going to give you another opportunity to comply with this process. If not, you're not leaving me with any other choice than to just have me sit in jail until we can get it taken care of.
All right.
Do you have any questions about that?
No, sir.
If your numbers change, if your address changes, it's your responsibility to let your lawyer know, certainly. And also the court, so that we can get a hold of you. You understand that?
I do.
Okay. Ms. Davis, do you want to meet with Mr. Simmons right now?
I can get them.
So meet with Ms. Davis here before you leave. Court will set this for a sentencing hearing at the next available date. If you have any questions about when that date is or what you need to do, Mr. Trush to make sure that you're, you know, where you have to be and when, and that you're prepared to go forward. Okay.
Absolutely.
Thank you so much. We'll take a short recess. We'll come back on the record in 10 minutes with Ms. Davis.
Your Honor, I would just indicate, I think the only other matter I have besides
podium, please. We're on the record in People versus Daniels, case number 236579. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record, Mike Roll, behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Daniels.
And get Ms. Daniels present here in court today. Ms. Daniels, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, sir.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of guidelines?
No, Your Honor.
Mr. Rolla, any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring of guidelines?
None, thank you.
Anything on behalf of the people for allocation?
Judge, this is a retail fraud, first degree, guidelines are 0 to 3, it's a first felony situation. And this plea entering request through IDA probation. This is a circumstance, of course, well aware was the defendant, 3 others, that they apparently got together and decided to try and wheel 2 shopping carts full of product out of Walmart. It was all fortunately fully recovered. I think the recommendation is appropriate. We ask the court to follow the same.
Thank you, Mr. Trush.
Thank you, Your Honor. I don't have a lot to add to that. Ms. Daniels is 20 years old, has no prior misdemeanors, no prior felonies. This would seem like an ideal case for treatment under HIDA. From my discussions with Ms. Daniels, one of the things that we've talked a lot about is, the power of reputation. And, the power of reputation in terms of if you have a criminal history, how that affects how people view you. It can affect jobs and all sorts of other things. So, the opportunity for her to have treatment under HIDA, I think, is incredibly valuable. And we would just ask the court to sentence under that statute.
Ms. Daniels, anything that you wanted to say?
I was just like, I'm sorry, Your Honor. It's very out of character for me. It's not a path I'd like to go down the line.
I did read through the report, so I'm familiar with what happened here. I'm also familiar with your background and circumstances as well. And I think the recommendation of probation is appropriate. You haven't been in any trouble before. You're 20 years old.
Yes, sir.
You don't want to start down that path now, because as Mr. Trush said, it's going to lead you to a lot more trouble. And life's hard enough without making it harder on yourself. A lot of it too, I think, as you'll see as you get older, is the people that you hang out with, associate with. You want to be with people who are going to lift you up and not drag you down. And I hope that you'll think about that too, and the people you're associating with. Make some changes there. I think that based on your previous history, there's no reason why you can't successfully complete this probation, move on from this, and not have to be on your record. And I hope that's the way that it goes, because that's going to be the best for you going forward.
Thank you, Your Honor.
Yeah. And what I want for you is to sign a successful discharge a year from now and have you move on from this.
Yes, sir.
So the court is going to place you on probation for a period of 12 months pursuant to the Homeless Youthful Trainee Act. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. 1 day in the Otsego County Jail with 1 day served. A $130 crime victims assessment. Court costs of $325. DNA testing fee of $60. $68 state costs, and a supervision fee of $30 per month while you're on probation. Because this is pursuant to IDA, there are no appellate rights. And Ms. Davis, do you need Ms. Daniels to check in with you before she?
I already spoke.
You did? Okay.
Thank you.
So, Ms. Daniels, just make sure that you follow through with anything that your probation agent needs you to do. And good luck to you going forward.
Thank you.
we have a hearing with Mr. Arsenault? I had it on my docket, but I don't see it on the schedule here.
I believe we do. And I showed it 3:15.
That's my understanding as well, Judge.
If we don't, I'd like to.
What's
You
the,
got them here, okay. We'll go on the record in People versus Arsenault. Number 236581. Mr. Arsenault is present today by video from Otsego County Jail. If I could have council put your appearances on.
For the record, Judge, calling back people.
Thank you, Your Honor. Richard Truce, on behalf of Mr. Arsenault.
Mr. Truce, how did we want to proceed on this file today?
So, Your Honor, there's two things we'd like to address today. The first of which is we are in receipt of a revised offer from the prosecutor. I've discussed that with Mr. Arsenault. It's our intention to take advantage of that. That would be a plea to counts 1, 2, and 3 in the amended information, the habitual offender notices, actually all the enhancements would be dismissed. We intend to take advantage of that, and then, Your Honor, we'd like to address bond to the court as well.
Did we have a copy of that information on that signature in the file? The original felony complaint, there isn't a.
no,
Your Honor, I don't have a
There's
copy.
not an amended information 1, 2, and 3 yet. We just discussed this, quite frankly, yesterday.
Okay.
Defense counsel. But it would be a plea to counts 1, 2, and 3 without the enhancement. So the language would be the same as the original information, just.
So my problem is I don't even have the original information. I have a 2-count felony complaint.
So they take a look, Judge.
There was an additional count that was added of a absconding on bond.
Correct, Judge, because we had to go to San Diego.
Okay, so we have count 1, which is possession of methamphetamine, count 2, which is R&O, and then a count 3 of absconding.
Correct, Your Honor, and I give the court the site for that.
Please. What is the maximum penalty for that?
That is a 4-year offense, Your Honor, and it is, and the PAC code is 750.199A.
All right, so those 3 counts with the habitual 4 dismissed.
Correct, Your Honor.
And the controlled substance, second or subsequent offense is also being dismissed.
Okay. All right, Mr. Arsenault, were you able to hear all of that?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. Mr. Arsenault, you can lower your hand. You understand that the maximum penalty you could face for possession of methamphetamine is up to 10 years and/or a $15,000 fine?
I do.
You understand that the maximum penalty you could face for absconding would be up to 4 years?
Yeah, I do.
And then the maximum possible penalty you could face for resisting or obstructing a police officer is up to 2 years and/or a $2,000 fine.
Yes, sir.
Truce, are you aware of any consecutive sentencing sanctions that may apply?
I do believe he was on bond for the file that he's currently serving a sentence for when this occurred. So I do believe the court does have discretion.
Okay.
That's correct, Judge. It would be mandatory. We would be discretion.
All right. So another thing, Mr. Arsenault, that you have to understand is because you were on bond at the time that these crimes allegedly occurred, that the court has a discretion to make your sentence consecutive However, the court is not required to do that. Do you understand that?
Yes, sir.
Are you on any kind of probation, or were you on any kind of probation or parole at the time that these instances occurred?
No, nothing, sir.
Okay. So with all the things that we've discussed here on the record today in mind, what is your plea to those 3 charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty of each of these crimes?
I am.
All right, so back on March 27th of 2023, were you present here in Otsego County?
Yes.
At the time that you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that substance was?
Yeah, I did.
Did you have any legal right to have it at that time?
No, sir.
And during that incident, did you come into contact with a Gaylord City Police officer, Officer Nagy?
Yeah, I mean, yeah. Yeah, I did.
So during this interaction with Officer Nagy, was there a pipe that you had on you?
A pipe?
Yeah, a glass pipe?
Yeah, I had it in my sock. Yeah.
Okay, and during that interaction, did you try to conceal that or hide that from the officer?
I stepped on it. It was in my sock.
Okay, and had he asked you if you had anything illegal on your body at that time?
Yes.
Aaron, I think that would form the basis there.
Was that police officer wearing his uniform at that time?
Yes.
Did you know that he was acting as a law enforcement officer during that interaction?
Yes, sir.
All right, thank you. And then as to the absconding, Mr. Trush, I don't really have any information on that.
Judge, I can do that, or Mr. Truce wants to do it either way.
I don't mind asking the questions. Subsequent to that, you were released on a bond, is that correct?
Yes.
And while you were out on that bond, did you leave this jurisdiction and go to California?
I did.
And that was,
Yes, sir.
and that was contrary to your bond conditions?
Yes. I just wasn't in the right state of mind.
And when you left the jurisdiction, you did not have permission from the court to do that.
No, I didn't.
I think that would establish the last one.
Mr. Roller, are you satisfied with the factual basis as to all 3 charges?
People are satisfied for sufficient factual basis to accept defendant's guilty pleas as to count 1, 2, and added count 3. People are satisfied the court has applied according to the statute as to acceptance of pleas. We're aware of no threats, promises, or other inducements not placed on the record. Thank you.
Mr. Trush?
I would agree the court has complied with court rule. I'm aware of no threats, promises, or inducements, and I do believe the court has a factual basis.
Thank you, Mr. Arsenault. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. In the meantime, someone from probation will be in touch with you regarding a pre-sentence report. Mr. Trush, wanted to raise the issue of bond. It looks like it's currently set at $10,000 cash or surety.
It is, Your Honor. I'd ask the court to consider a reduction in this. So a few things for the court to sort of think about structurally where we're at. So Mr. Arsenault is currently serving a sentence. He was sentenced in July, I think on July 17th. I believe he's actually been in the jail a little bit longer than that. I think about 60 days longer than that period of time. He's under that sentence. The court has in that file signed an order allowing him to enter the work camp program as long as he's eligible through the program. The only thing that's holding him up right now is this pending charge. So again, he's been in the jail for a fairly significant amount of time at this point. It's anticipated that the guidelines on this file are going to be on a straddle cell, meaning the court's going to have discretion as far as what a sentence should look like. But I would also indicate to the court, obviously, there's two parts of any sentence, as the court knows. There's a punishment element of it, and then there's a rehabilitation element of it. Given that Mr. Arsenault has already spent a fairly lengthy amount of time in the county jail, I would ask the court to consider that really what we should be looking at here is the rehabilitative part of it. And if the court reduces his bond and allows him to start participating in the work camp program, or even if the court left the bond at the same amount but made an amendment to the bond to allow him to do work camp, he would be able to get out and start that rehabilitating process.
Thank you, Mr. Rolla. Do the people have any position on that?
We do, Judge. All what defense counsel said so well and good. The fact of the matter remains, after he had an order of this court, the defendant fled to San Diego where he committed other crimes. That's why he was in the San Diego County Jail. If given work camp, and again, the court has the authority to do that, I understand. But again, if given work camp and he is not incarcerated, there's no guarantee he's going to be here to be available for the PSI like we've had other people earlier today, much less be appearing before this court for sentencing.
All right,
Just briefly, I mean, I somewhat disagree. I mean, he would be reporting daily to the work camp. So, I mean, it's not as if he would just be out there unfettered. I mean, there would be supervision over him daily, making sure that he's doing what he's supposed to be doing.
all right, so got a plea entered in this case. One of the charges is absconding. I'm not sure that I was aware of that at the time that I granted work camp as part of his current sentence, although I wouldn't foreclose that necessarily as part of the sentence in this case. I think given the fact that one of the charges that Mr. Arsenault just pled to was absconding, I think bond's appropriately set. I think the conditions are appropriate for now to ensure that we proceed to sentencing without expending any more public resources or funds, or risking that Mr. Arsenault were to again abscond. So the court's going to have the bond remain as it is pending sentencing in this case.
And we just ask that the sentencing be set as quick as the court can.
We'll do, the court will set this in its normal course. That's all for today, Mr. Arsenault. Thank you. The court's going to disconnect at this time. Are we ready with Ms. Murphy's case?
Yes, Your Honor.
People versus Roseanne Murphy, case number 236562.
Thank you, for the record, my role on behalf of the people.
Mary Beth Kerr on behalf of the defendant.
Set for a pretrial scheduling hearing in this case. I believe this is Ms. Murphy's first appearance before court. Okay, it looks like we have a plea resolution.
Yes, sir.
Okay, can you tell me the terms of that?
Yes. My client is going to enter a plea to count one. as a third offense. The habitual second is gonna be dismissed, counts 2 and 3 are gonna be dismissed. And it's my understanding that if the logistics can be worked out, and if it's even a possibility, there would be no objection on the prosecution's behalf to problem-solving court, either here or down near where she lives.
Mr. Rolla?
Two additional things, Judge. One, there's a $200 blood test reimbursement that's required by statute. And as to the latter request regarding drug court, as the court is well aware now, it has to be a complete transfer of jurisdiction. It can't be just sending them there. That's pursuant to a decree got brought down from state.
Okay. Ms. Murphy, have you had an opportunity to speak to Ms. Kerr about the plea agreement?
Yes.
And what we discussed here on the record today, is that your understanding of what the agreement is going to be?
Yes.
Is that how you want to proceed today?
Yes.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Ms. Murphy, are you currently on any probation or parole? And you understand that the maximum possible penalty that you could face for operating while intoxicated as a third offense is up to 5 years and or a $5,000 fine?
Yes.
And with that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you. The right to testify at a trial yourself if you want it. You understand all of those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. You won't have those.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty?
Yes.
This happened on March 9th of 2023. Is that the correct day?
Yes.
On that day, had you consumed some controlled substances, looks like some prescription medications?
Correct. But they aren't controlled substances.
Prescribed.
They're prescribed.
Prescribed substances.
I inadvertently took my evening medication in the morning when I was driving.
Okay. And so you took those medications prior to driving?
Not prior. It was after I was coming from the Sioux, and it was after I crossed the bridge.
Oh.
And then you resumed driving, correct?
Correct.
And you were
Yeah.
stopped in this county after that, correct?
Correct. I had, when I travel sometimes, I will put my morning and evening medications in separate little bags, and I put the wrong bag in my purse.
Okay.
So that's,
I have a signed advice of rights. I didn't know if you wanted that, Judge.
I went through it with her on the record, but I'll take that to the file as well.
May I approach?
Yes. Ms. Murphy, had consuming those substances caused you to be intoxicated to the point that you were no longer able to operate that vehicle in a normal and safe manner?
yes, and I did realize that, and I was trying to pull over, and that was when I was stopped.
Okay. Had you previously been convicted of operating while intoxicated back in 2013 in Oakland County?
Yes.
And of operating while impaired back in 2007 District Court, Michigan?
Yes.
Mr. Rolla, are the people satisfied with the factual basis?
Judge, just that, where she's operating was on a public highway.
Did you get stopped on I-75 or M-32 here in Otsego County?
I was exiting to Gaylord, right out.
So the answer is yes.
Yes.
Thank you, Judge. People satisfied with putting down the factual basis for defendant's plea as to count one. Courts complied with court written statute, acceptance of police and aware of no threats, promises or other inducements not placed on record.
Or are the defense aware of any threats, promises, or inducements other than what's been placed on the record?
No, and I do believe we've complied with the statutes and the court rule with regards to the foundation for plea.
Ms. Murphy, the court finds your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You're going to meet with Ms. Davis here right before you leave court to set up the time for a pre-sentencing review, okay?
Okay.
Ms. Kerr, anything further on this?
I wondered if Mr. Rolla and I could approach the bench.
Yes. Our next matter is People versus Danielson. That's set for 3:30. We're going to take a short recess and we'll come back on the record at 3:30.
And with that in mind, do you want me to proceed with the council table?
Let's start at the podium and then I may have you go to people. If we want to address the court. This is the date and time set for sentencing in this matter. Mr. Sin, have you had a chance to go through the pre-sentence report and to talk to Mr. Clayton about that?
Yes.
Yes. Mr. Clayton, are there any additions, deletions, or corrections that need to be made to the report? I think on the basic information report, it indicates 11 probation terms. I'm assuming that's print.
There would necessarily have to be Ms. Princeton for 16.
Right. I think that's got to be one. Are there any other corrections, Mr. Clayton?
No other corrections, Your Honor. And reviewing this, going to the sentencing guidelines, that I can underscore properly, it's 0 to 14.
All right, thank you. Mr. Rolla, are there any additions, deletions, or corrections?
Judge, I think it actually should be 2 probation terms, not 1 probation term.
Any objection to that change, Mr. Quinn?
No.
Okay.
No other additions or deletions to the body report or challenges as to the score, Judge. Thank you.
Okay, and I did review the victim impact statement as presented in the PSI. Does the victim wish to make a statement for the court today?
She does, Judge.
Okay, so yes, Mr. Clayton, if you and your client wish to be seen. And ma'am, if you'd like to come forward to your first. Right up there. And can you tell me your name for the record?
Tiffany Deschamps.
Okay, Ms. Deschamps, can you tell me what it is you'd like the court to know?
I kind of would just like to read my statement. I know that you read it. I don't know who else has, but I just kind of would like it so everybody would hear it.
Absolutely. Please proceed.
My name is Tiffany Deschamps. I'm 34 years old. I've had the privilege of being a stay-at-home mom for the last 6.5 years, taking care of my 13-year-old daughter and my 5-year-old son, running them to sports practice and school, and everything in between. Cooking, cleaning, running errands, taking care of everything household related. While my boyfriend works to pay our bills, and I also take care of my 83-year-old grandfather. Now you know a little bit about me. The reason I'm here today in front of you is because on April 2nd, 2023, at 7 p.m., my life was changed forever. I was returning home from going to the dollar store in Joburg, 7 miles from my house. I was involved in a hit and run accident by a drunk driver and ran off the road at a high rate of speed, all because I passed him in a safe passing area. He was traveling 10 miles an hour, and when I passed him, I was going about 25. He ran me down a hill through an intersection into a ditch, while I had my foot on the brake the entire time. As a result, my car was totaled, and I was left for dead as he fled the scene in a totaled full-size truck. I had to walk to find cell phone signal to call 911 twice, as I have my bone sticking out of my arm. Now I have permanent damage to my right dominant arm with 2 metal plates, 12 screws, a severed nerve, torn muscles, and in the hospital for 2 days, 6 weeks in a hard cast, 6 weeks in a splint, months of physical therapy, traveling hundreds of miles to countless doctor's appointments, while my boyfriend took months off of work to take care of me and our children and our daily household chores. I never thought or knew, for that matter, that a car accident would change my life forever. I can no longer travel down Gingell without picturing every second of the horrific accident. I can no longer take care of my family the way I had before. I have horrible nightmares. I have terrible PTSD. Every Ford truck that's behind me, I think it's Danny. The whole accident replays in my head over and over. cannot control my body or emotions. Every day I'm in pain. I do not think my arm will ever heal correctly. I have 2 disgusting scars and 4 metal in my body. That is a reminder every day. Every day this accident impacts my life in a different way. I have to live knowing my children suffered from coming to the scene of an accident, seeing their mother on the side of the road in a totaled car. My daughter and my son do not want to travel in a vehicle to go to school as we travel down Gingell to take them to and from school. If we need to go to the store or the lake, where that's one of my favorite places to be. For a long time, they didn't even want me to leave the house. My 13-year-old daughter is helping me in every way possible. She helps me bathe, get dressed, helps me take care of my son, as does her father too. My boyfriend has lost out on a lot of work because he needed to pick the kids up from school and take care of them and me, because I could not do that for myself anymore. So we lost a lot of money to pay our bills, feed our children, and to pay for necessities. And now on food stamps because we cannot afford food. And not to even mention all the unnecessary running around for all of the doctor's appointments. For the first few months after my accident, I laid on the couch. My depression got pretty bad as I watched my kids be sad because I could not do anything with them. Some of the things I can no longer do the way I used to be able to. I cannot cook properly. I cannot go out to restaurants without feeling self-conscious because people stare at me. I can't garden. I can't do simple things with my children that I once was able to do, as kayaking, fishing. I can't swim. I can't take them to the beach. I can't ride a bike. Can't play with them at the park without worrying about injuring my wrist and arm further. I don't like to drive anymore, so we don't go on trips far away from home. I can't take my son fishing to do one of his most favorite things in the world, take my daughter horseback riding, any of those things. Finally, after about 5 months, I'm able to start shaving my own legs. Do you know how embarrassing it is to ask your partner or your daughter to help you shave your legs? Every day is a new day. I try to start out as positive I can, but the list of things I cannot do with my bad arm is definitely longer than the list of things I can do. I know I'm alive and I'm grateful for that. I understand that it could have been way worse. My children have lost a piece of their mother that I don't know if they'll ever get back. It breaks my heart for my children to suffer along with me and their father because of the actions of some other person that has shown no remorse and has not taken any responsibilities for his actions. Instead, the man responsible continued on with his daily life and carefree. I have countless people contacting me saying this is not the first time he has gotten in trouble for drinking and driving when this first happened. The phone did not stop ringing. These other people calling and say that he wouldn't get any punishment for this accident as he gets off every time. A few phone calls I have received, I don't really want to go through all of that. I just want to know when it's all the phone calls and messages and everybody coming to me is going to stop. All it does is make me stressed and panicked. I can no longer live like this. I've blocked numbers and even of some of the people, even though they don't have bad intentions, it's just too much for me at this time, but it does not seem to stop. Those are a few things in my everyday life I have to deal with. I'm trying to get better. I'm seeing a therapist to mentally get through this tough time in my life. But I also, every day, find something else I'm not able to do. I will have to live with this disability for the rest of my life. I am 34 years old. I have no idea what the future holds or if I'll ever be able to use my hand and arm properly again. If I'll be able to have a job, if I'll have to have surgeries again. All I do know is that I will have to live with this. I do not think it's fair because of a man's drunken road rage after drinking too many Budweisers at a local Joburg bar and being overserved alcohol, getting behind the wheel of a car when the bar clearly should have called someone to take this man home. Now, you asked me what I think would be a fair sentence to him. To me, only God can judge, and I do not feel comfortable putting a timeline on someone else's life. Maybe it would be fair for him to stay in jail until I am back to the way I was before this accident, so he does not hit and kill somebody. It may take 1 year, may take 10. There's no excuse in the world for his actions of this man on the evening of April 2nd. I would not wish this upon my worst enemy, the local man who everyone knows in this small town of Joburg, also known as the town drunk. A local businessman in an automotive body repair business. I wish you could experience the pain I feel, the depression I've been going through, as I've sat on my couch helplessly for 6 weeks. I know you remember every second of the accident. I know you remember hitting my car. I know you remember driving both of us off the road into the ditch. I know you remember asking your dog if he was okay. I know you remember asking me what you could do to make this better, and when I told you my arm was broke to call 911. I remember you getting into your truck and pushing your airbag down and driving away as fast as you could. These are some of the things I have to live with now on a daily basis and will have to learn to live with the rest of my life. I respectfully ask the court to punish Mr. Sin accordingly based on the seriousness of his crime and the fact that he has not taken responsibilities for his action and in fact drove drunk after this accident again. I would never be able to live with myself if I did not ask the court to take this man off the street, and if he ends up killing somebody, he deserves to go to jail for this crime. And I ask the court to impose the maximum sentence to not only allow me peace of mind, but maybe to save the next person's life. Thank you.
Thank you, Ms. Bishop. Mr. Clayton, if you're, excuse me, you were in your flag, want to come back up a little bit? Sure, please. Mr. Rolo, was there anything that you wanted to say on behalf of
Briefly,
the
Judge.
for application?
Thank you. The case, as it's been made very clear from the victim, from the statement, matter of drunken road rage. We are fortunate to the extent that since a vehicle was driven across an intersection of Spar Road, this wasn't a multiple vehicle fatality accident. So if there's anything that can be grateful about this incident, perhaps the defendant should be grateful for that, regardless of what sentence the court's going to impose. As indicated, he has another matter. This is the defendant's third drunk driving since the 1990s. He had one in 95, one in 98, which is reduced in the district court, and which, due to a 10-year gap rule, 2 of his prior drunk drivings aren't even accounted for by the sentencing guidelines. In this case, the victim effectively was left to die with bone sticking out of her arm. The defendant contacted her, supposedly, as it indicates in the report, and as indicated by the victim, and he simply told her, "You shouldn't have passed me." I can't even fathom that. What makes the matter even more obscene in this case is that after the accident, where does he go and park his truck? Back at Paul's Pub, the local bar. Why he does so, why he did so, I don't know. But I concur with the victim's statement that unless this court takes action against the defendant, he is going to wind up killing somebody. We've already heard about that earlier today on other incidents. I don't want to be here back for that matter. I doubt the court does either. Thank you, Your Honor.
Thank you. Mr. Clayton, anything on behalf of Mr. Sin today?
Yes, sir. A couple things. First of all, and I hate in my comments to respond to comments from Mr. Rolla, because my comments should be unique to the case, but I think Mr. Sin has taken responsibility. He's taken responsibility for this. He's taken responsibility for his case in the circuit court. The Michigan legislature decided by their rules that if there's a 10-year crime-free period, those crimes don't count. Not that the court can't consider them, but for the purpose of guideline scoring, they don't count. Mr. Sin has not had a conviction and not over 10 years, and over 20 years. I know we all, just by human nature, naturally assume that people leave the scenes of accidents because they're drunk driving. I've not seen the evidence of that in this case. Maybe the case, I don't know, I wasn't there. The fact is that Mr. Sin admitted to what he did. He should have stayed at the accident scene, and maybe all these questions would have been answered if he had. And that's on him, and that's what he's here to be sentenced for. His guideline scoring range is 0 to 14, which is intermediate sanction. So on most cases, maybe not all, but on most cases, that would be indicative of no upfront incarceration. This case may be different because the court has to look at two factors. That's the offender and the offense. As the court looks at the offender, obviously Mr. Sin has a 23-year crime-free period. This is the first involvement since the late 90s with the criminal justice system. So from the offender standpoint, he scores out as an A. Granted, under the sentencing guidelines, under the offense variables, the offense, he scores out as 6, which totals out of E grade to a 0 to 14. And I'll say this in no way pandering to the court. Judge Mertz, I've been in front of you on many occasions, and I always found that you make the right decision. Might not always be the decision I like. I can say that sincerely, but I think you put a lot of thought into your sentencing decisions. I think that the court could fashion probation terms that be appropriate for Mr. Sin. He is older. He has performed well on bond. These are things the court should consider and will consider in imposing appropriate sentence. I'll simply ask you to use your wise judgment as you have in previous cases.
Thank you. Mr. Sin, is there anything that you wanted to say today?
I'm just very sorry that this situation from happening, Your Honor.
All right, so I did have a chance to review the report. I'm familiar with what happened in this case.
Okay.
I take all of that into consideration, along with what the victim had to say. And Ms. DeShone, I appreciate you coming in and making that statement. It's obviously a very emotional issue for you. It's not an easy thing to get up in court and make a statement like that. And to talk about what happened to you. I think it sets a good example for other victims because people need to come forward. They need to have their side of the story heard. It's important. It's why the law allows for that. And so I think it's a good thing for you to do, and I think it's a good thing for you to do for other people to see you doing that. So I appreciate your statement, and that has a great deal of impact on the court, because it's one thing to read words on a piece of paper. It's another thing to hear how crime actually affects a person. And it's clear to me that this has deeply affected Ms. DeShone, as I think it would anybody. I don't think her reaction is in any way out of the ordinary for somebody who's gone through something like this. There are some mitigating factors here, as Mr. Clayton indicated. Your previous crimes were a long time ago, and you, by your record, went for a long period of time without having any interactions with the justice system. You are a business owner. You've carried on a successful business for a long time. And all of those are things that work in your favor. In my view, there are a number of things, however, that make this case particularly egregious. Number one, the court doesn't have to, make any findings by a particular burden or level of proof. I can look at the report and draw my own conclusions at a sentencing hearing, and in my view, there's no question in my mind that you were intoxicated when this incident happened. I understand that you weren't arrested and your blood level wasn't checked for a period of time after that, and it's certainly possible that you continued to drink after this accident happened, but there's no question in my mind, based on all the circumstances as I see them, that you were intoxicated at the time that this happened. That's an aggravating factor. I think based on what I read, that you had an intent to run Ms. DeShone off the road because of what you perceived was, her passing you when she shouldn't have passed you. I think based on what happened, your statements to her at the scene, as well as just the circumstances of it, indicate that to me. That's a frightening thing, that you were so angry by somebody who passed you that you were willing to run your car into someone else and potentially hurt them because you didn't like what they did on the road. That's an aggravating circumstance. The fact that you talked to Ms. DeShone after this accident and either did realize or certainly should have realized the severity of her injuries and didn't stay there to call for help. I'm familiar with that intersection. It's kind of in the middle of nowhere. There's no good cell service there. You left her there to fend for herself with a very serious injury. I'm sure given the nature of that injury, she was in shock. And to leave somebody in that condition, which I can only presume was to protect yourself and to get out of there so that you wouldn't get in trouble for what you did. That's the way it looks to me. That's an aggravating factor. Ms. DeShone referred to this as a car accident. This was not a car accident. This wasn't something that just happened. You caused this to happen. It didn't need to happen. That's an aggravating factor. The fact that you continued to drink and drive after this and got arrested again for operating with a high BAC, not even just operating while intoxicated, but operating at a level that in Michigan we call it super drunk. You did that after this happened. That's a major aggravating factor. That tells me that this didn't really have any impact on you, this incident, because you continued to engage in the same behavior after it happened. That concerns me. That makes me wonder that if I put you on probation, whether or not you're going to go out and do the same thing. And while Ms. DeShone, I think, was extremely lucky that her injuries were limited to what they were, as bad as they were, it could have been a lot worse. You could be here on a charge for killing somebody for what you did that night. When I look at what an appropriate sentence is, there are those mitigating factors, but in my view, the aggravating factors far outweigh any of the mitigating factors. And when I look at the guidelines, which are 0 to 14, and I look at the scoring, I think there's a number of factors that weren't properly taken into account by the scoring. Number one, OV5, which is psychological injury to the victim, that was scored at 0. I think it's clear based on Ms. DeShone's statements here today that she has suffered psychological injury as a result of this. She was.
OV5 is a psychological injury to a member of a victim's family. That's only scored in murder cases.
Oh, I'm sorry, OV4. OV4 is scored. All right, well, I had a mistake on that.
I didn't mean to talk.
No, I'm glad that you corrected that, because that's true. That is taken into account under OV4. But it's clear to me that there has been serious psychological injury that's occurred to Ms. DeShone as a result of this incident. Again, I think that there was an intent on your part to ram her vehicle to cause an injury to the person that passed you that night because you were upset about it. That's something that isn't accounted for in the guidelines at all. The only thing that comes close to that is OV6, and that's not scoreable in this case because of the nature of the crime. But in my view, you clearly had an intent to injure somebody for what they did as part of a road rage kind of reaction on your part. And so that's something that's not taken into account in the guidelines. OV13, which involves a pattern of behavior, again, that's not scoreable under the circumstances here, but I think the fact that you engaged in drunk driving and at a serious level of intoxication following this incident isn't taken account into the guidelines, but I view it as a pattern of behavior on your part that causes me concern for what would happen in the future. So So I think there are variables that weren't properly taken into account, that weren't properly scored in this case, that result in a guideline range, which is inadequate, in my view, to account for your behavior in this
Can
case.
I say one thing, sir?
Sure.
As I was I had the right of way to make a turn off M32 to go on North Kinsel. There's another car coming towards me. No blinker. As I was turning, they pulled right into me and I didn't swerve my truck and put it behind the ditch, behind the stop sign, in the ditch. We still had snow on the road a little bit. It kept right on going. Thank God it had four-wheel drive. I got out. I said, I wanted to get this license plate number on this vehicle because I wanted to turn it in the sheriff's department. Well, I got up upon it and I got my pencil, piece of paper, and you slammed on the brakes and I hit it like that and my airbag moved and I lost full control of my vehicle. It's unbelievable. I'm sorry for what happened. But that's what happened.
I understand that's your side of it. I don't accept that version of it.
See, this person never passed me. They put me in the ditch.
Okay.
Behind the stop sign.
Okay.
You know, if I didn't swerve, they would have took the whole left side of my truck out.
I understand that's what you're saying. When I read in the report, I view it differently than the way you see it. I think you were intoxicated. I think whatever Ms. DeShone did and however you took it, you viewed it as something you didn't like and didn't think she should have been doing. And based on your statements to her at the scene, I think it's something that you did intentionally as part of a road rage kind of reaction. And you can have a different version of that. You're entitled to your version, but that's not the way I see it.
Yeah.
And I think your statements here today are more along the lines of just not accepting responsibility for your role in this. And I think that's unfortunate. And again, that gives me concerns about the safety of people in the community if you're allowed to be out driving. Because I think next time somebody else may be not as lucky as Ms. DeShone was, as serious as her injuries were. Because I don't think that the guidelines adequately account for your behavior and your actions in this case and the danger that you pose to other people through your drinking and driving, for the reasons I've stated, I think a sentence outside the guidelines is more appropriate. And the court is going to impose a prison sentence. The court is going to depart from the guidelines. The reason for the departure, again, is that for the reasons I've stated, the guidelines as scored don't adequately account for your behavior and the results in this case, or the damage that was caused. When I take into account those factors, such as that I believe you had an intent to cause an accident or to injure somebody, when I take into account points that I think should be scored for your failure to correct your behavior and your actions in engaging in drunk driving again after this, if we add points in for those kinds of behaviors which aren't adequately accounted for, it results in a sentence that's more towards a 24-month sentence. And so the degree of departure, again, I think is justified by adding points in to adequately account for those factors that aren't accounted for, which I think justifies both the departure and a degree of departure to 24 months. The court is going to sentence you to 24 months in the Michigan Department of Corrections to 5 years. You do have credit for 3 days served. The court is going to order that you pay restitution in the amount of $1,000 that's payable to the Otsego County Clerk to be dispersed to Tiffany DeShone. Crime victim's assessment of $130. Court costs of $325. DNA testing fee of $60. $68 state costs. You do have the ability to seek an appeal of this sentence. Mr. Clayton, if you could provide those appellate rights of Mr. Sim.
I'm just telling you what I'm doing, David's kind of, these are your colored rights. Seek to appeal the judge's sentence, so you need to return for it. The information filled out, and just sign that there, just initial. Here? Just initial right there. We return that to the court and then give you a copy. Right, close first one.
Yes. Are remanded to the custody of the state at this time.
You're not gonna use this one, you know. That's Jerry, you can take that with you, okay?
They did. I think being the state, so. Okay.
Yeah, that said, working with those state funds, in your pocket. So if you're talking over your chair. Okay. All right, both that.
My bad. Yeah, thanks.
Mr. Doman present?
Yes, John.
Mr. Doman, if you want to come forward, we're going to have Ms. Tierney connected here on video in just a moment. Ms. Tierney, are you able to hear me okay?
Yes.
Okay, thank you. And Mr. Doman, if you want to come up to the podium, that way she can see you. Yeah, certainly. We're on the record in People versus Tierney, case number 104180. The record should reflect Ms. Tierney's present by video from Otsego County Jail. If I could have counsel put your focuses on.
Good afternoon, Your Honor. Tim Doman on behalf of Sarah Tierney.
Thank you. This is defendant's motion for reduction of jail sentence. I did have a chance to review your motion, Mr. Doman, as well as the exhibits attached to that. I also had a chance to review just generally Ms. Tierney's file since I wasn't presiding judge previously. So I'm aware of the underlying facts as well as your basis for the request. Is there anything that you wanted to state by way of oral argument today?
Yes, thank you, Your Honor. And I do think the motion covered just about everything I wanted to say, so I won't stand up here and repeat everything or go through all the exhibits because I know Your Honor has reviewed them, but just a few points I'd like to make this afternoon. First, I just wanted to say that I don't routinely file these motions every time I have a client with a jail sentence. I think this is a motion that should be rarely filed and really reserved for compelling circumstances.
And I think this is that rare case. So just looking at the language of the statute, it gives Your Honor discretion to reduce the jail sentence by a quarter if the client's conduct, diligence, and general attitude merit such reduction. So I think the focus here should not be so much on the offense, but rather what my client has done during her time while she's been incarcerated. So here she paroled out to the jail in June of this year. She's had no misconduct since then. She attends AA, she goes to church, which my understanding is really the only programming available to her at the jail. But I think it's fair to look at her MDOC record where there was much more that was available to her. And, when I do resentencing sometimes and I come back in front of the judge, if I have a client who I know has kept a clean prison record, I'll present that evidence to the court. And a lot of the time the judge will say, well, when I send someone to prison, I expect that they're going to be behaving themselves. So that really doesn't impress me much. But here, Ms. Tierney was not only staying out of trouble, she was really going above and beyond in terms of programming, education. I think education was a huge focus for her. And long story short, she made use of her time. And really, I think the crowning achievement was that associate's degree that she was able to get from Jackson College. So I don't have statistics offhand, but I think it's fair to say it's probably a small percentage of the prison population who's walking out with a college degree. And just in my own experience, I've been in private practice now for going on 10 years, doing pretty much strictly appellate work. So I do see prison records and things like that. And I, in my experience at least, cannot recall a client who's done more with her time than Sarah. One last point I want to make, and I think I may have misstated this in the motion, but Ms. Tierney is on parole right now. Her jail sentence is part of her 2-year parole term, which is kind of taking away from the idea of parole as supervised release and having a period of time where she can be supervised, reintegrated, where she's being offered services to aid her transition back into society. And as her parole agent wrote in the letter that was attached, she has no concerns about Sarah being released from jail early. So again, I think this is a motion that should be rarely filed, should only succeed in compelling circumstances. And I think this is that case. And really in the grand scheme of things, my client's been in prison now been incarcerated for almost 15 years. We're talking about a few months, which may not seem like a lot, but it would get her home at least in time for the holidays to spend time with kids, with grandkids who she's never met outside of prison. So for all those reasons, I would respectfully ask Your Honor to grant our motion. Thank you.
Thank you. Mr. Rolla, do people have any position on the motion?
We do, Judge, first and foremost, and people do not wait notice on this particular matter. We received no notice of hearing this particular matter. And I find it odd that there's this talk about her imprisonment when in fact that's actually what the defendant was sent to prison for. More importantly, perhaps, as well as the notice situation, that should people have been filing a response and required to apply, the people would point out very simply that, one, look at the date when the defendant was sentenced. At no point in time since then has there ever been a claim that it was an invalid sentence. And under the court rules as they exist now, this court has no authority to set aside an invalid sentence. Additionally, if that were not enough, the court is also well aware that, as pointed out by defense counsel, the condition that she's in jail right now is part of her parole conditions. Very recently, our Court of Appeals has found that the circuit courts have no authority to alter parole orders because the parole board apparently has magic authority right now. I don't necessarily agree with that decision, but until our Supreme Court says otherwise, quite frankly, we're stuck with it. In any case, this matter shouldn't even be before the court because there was no notice of hearing filed. And again, the people don't wait on that report.
All right, so Mr. Rolla, I mean, I think the only remedy for that is to reset this for a hearing if you want the opportunity to respond in writing if you weren't properly served with notice. Then I think that's the remedy. So I guess my question is, is that what you're asking the court to do?
Again, if the court wants to.
What I'm saying is I don't think I can deny the relief solely because you weren't provided notice. I think the remedy is to allow you a chance to respond.
And again, the court's heard my arguments as to and I know the court's familiar with the law. So those would be the points I would be making, the court will want to rule on today.
Okay. All right, so do you have an objection to the court ruling today or?
No, Your Honor, go ahead.
Okay, all right, thank you. Mr. Doman, any response? This is your.
Yes, Your Honor, thank you. And I filed the notice. I think I sent it in. I can't explain why it wasn't received by the prosecutor, but it certainly sent a proof of service was filed, I believe. In terms of, Mr. Rule is correct. You know, the standard rule is that if sentence cannot be altered unless there's some kind of invalidity, but the statute obviously is an exception to that with jail sentences at least. In terms of parole conditions that she be in the jail, I'm not familiar, I have not seen a parole order that says that. I don't think this is a condition of her parole. It's just the fact that she has to serve this while on parole. So I don't think there's any kind of parole order that would preclude the relief here. And obviously the parole agent is in support of the relief. So with that, again, we would ask Your Honor to respectfully grant the motion.
Okay. I do note that there is a proof of service in the file that was filed on September 13th, indicating that Mr. Doman did serve the prosecutor's office with the motion and notice of hearing. Either way, I think that issue's, Mr. Roll has indicated it. He's waiving that issue in terms of any opportunity that he would be requesting to file a written response. And again, it wouldn't be a basis for the court to deny the relief. It would be only be a basis to give the prosecutor time to respond. I did review again the motion, and Mr. Doman, again, just for the record, if the court grants us relief, how much of a reduction is this going to result in?
Math is not my strong suit, but near as I could tell, it would get her out with good time sometime in the middle of November,
As opposed to
January, I believe is her current out date. You could correct me if I'm wrong on that, Sarah.
That's fine. I'm not asking for mathematical.
Are you asking? Oh.
No, that's okay, Ms. Tierney. I wanted to make a record of the actual time frame here. So,
Okay.
and I agree with Mr. Doman. This is a rarely used statute, and honestly, I've been on the bench for over 10 years. It's the first one I've seen, and so I had to look at the statute and do that myself. So looking at the law, I think it does allow for this relief. I think Ms. Tierney has served the vast majority of the time that she's been ordered to serve by the sentencing judge in this case. When we look at the breadth of her sentence, the amount of time that this motion would reduce that sentence by is really, in my view, insignificant in terms of the benefit to the community, benefit to Ms. Tierney in terms of rehabilitation and so forth. All of those goals should have been accomplished by this point, and 60 days is, in my view, not going to do any more towards accomplishing the goals of sentencing than has already been accomplished. I also believe and agree with Mr. Doman that this is the type of motion that should be rarely brought, even more rarely granted. When I review Ms. Tierney's record as presented, she has accomplished quite a bit during her time of incarceration. I do think it's notable that she received an associate's degree during that time. I agree that's not something, no matter how much somebody does while they're incarcerated, that's not something that I see very often. And then the other compelling factor for me is the opinion of her parole agent. And so those things all together, I think, warrant unusual relief in this case. So the court will grant a motion. Mr. Doman, if you present an order to the court, just indicating for the record that for the reasons stated on the record that relief is granted, and if you can either get a stipulation as to form for Mr. Rolla or submit that on the website.
I will do that, Your Honor. Thank you very much.
Mr. Rolla, anything further for the record?
Just that I would ask.
Thank you so much.
You're welcome.
that a calculation as to the time be reflected in the order. Again, I'm not saying defense counsel is gonna fudge the math,
No.
but I think it would be appropriate that it be in there to avoid any other further issues.
I think that's a good suggestion.
I agree, Your Honor.
Okay, thank you. That's all for today. Ms. Tierney, we're gonna disconnect at this time.
Thank you.
The last matter for today is Morrison versus Morrison, and Mr. Rolla will be the table there.
Oh, that's fine, Judge. I'll be happy with it. No objection at all.
Can I have Melissa Morrison come forward? And that's that table right there. Yes. Is Jesse Morrison present? Mr. Morrison? And you said where Mr. Roll is at there, CC versus, So we're on the record in Morrison versus Morrison. This is case number 2319422. We got both parties present here.